Thank you everyone for joining. We're just waiting for folks to file into the virtual Zoom room here, so we'll get started momentarily.
Yeah, Mark, this has become our standard part of the awkwardness of a Zoom panel.
Yes.
You have to have the nice version of sitting, waiting for a few minutes as folks join.
Yes. Looks like we have a great crowd here today for this session. We'll just give everyone another minute or so to file into the room, and then we'll get started. For those of you who are in the room, you should see a poll question. Please feel free to participate, and we'll show everybody the results here in a moment. And we still have folks who are filing in. Okay, great. Excellent. So thank you all for joining us this morning for the welcome address and opening keynote for the Spokes Privacy Technology Conference. My name is Mark LaFleur, and I'll be your WireWheel host. Thank you for all of you who participated in our poll questions. You should now see the results there on your screen. I'm excited to introduce your presenter for today's session. Justin Antoni-Pillay is the founder and CEO of WireWheel. Justin, I'll pass it over to you to introduce yourself and Bruno, and then I'll be back at the end of the session to wrap things up.
Terrific. Thanks so much, Mark. And first of all, Bruno, thank you very much for joining us here today at our Spokes conference. We're delighted to have you. And I'm going to start just very briefly here by welcoming everybody to Spokes. We've been absolutely blown away here at WireWheel by the reaction from the community to what we've been doing with these Spokes sessions in terms of, and our major focus has been to try to bring the best expertise on data protection, privacy, technology policy, and make it free and available to the largest and smallest companies, to law students, and to our community to democratize basically the understanding of some pretty hard concepts. Yesterday in our opening session, we had nearly 4,000 people join or view a really terrific discussion between Dan Solove, myself, Alex Givens from the Center for Democracy and Technology, and Cam Carey from the Brookings Institution about what technology policy will look like over the next 4 years. And it was great, and great to see the amount of participation from around the world on these sessions. I have a lot of people to thank around Spokes, but today, Bruno Gencarelli, who is the lead for International Data Transfer Unit and has a very broad portfolio at the European Commission, is joining us today, literally right in the middle of some of the discussions in London. And I'll let Bruno talk about that. But because time is short, I want to jump straight into a discussion and welcome our good friend, Bruno Gencarelli, to the discussion. So first of all, Bruno, thank you very much for taking a few minutes of time to come and join us today. I know that you're in London and traveling. There are a lot of major developments that happened even since we've last caught up around technology. Now, obviously, in the big picture, both in Europe and in the United States and around the world, the biggest policy issues and the biggest stress issues for almost every government right now are around the global pandemic, some of the very serious financial and other economic consequences. But of course, tied up in all of these are some very serious, very important technology policy issues. But with respect, and understanding that there is a lot going on, I wondered if you and I could just, first of all, say hello and welcome you here, but also just jump right into a discussion of some of the critical items that are going on. So maybe I just say, how are things in London, and how are things on the discussions around Brexit, for example?
First, thank you, Justin, for having me. This is a great event, a superb program. Good morning, everybody. Good morning, everybody in America, and good afternoon or good evening to the rest of your audience, who I'm sure is following also from us from other parts of the world. Indeed, well, yes, I'm in London. Those, as you may know, there is this negotiation ongoing with the UK on what could be the future partnership between the EU and the UK. The UK has already left the EU, but is still in what we call the transition period, which means that EU law, including EU data protection law, applies to the UK until the end of this year, until the 30th of December. And that transition period will end very soon, and therefore there are very intensive negotiations going on right now to try to reach an agreement so that a new partnership can be in place as of the 1st of January. So that's what is keeping myself and many other people busy.
Yeah, no, and again, I'm imagining there's very little you probably can say at the moment, Bruno, but nothing like waiting and giving yourself a nice long gap between the discussions and the end of the year around some of the deadlines. I assume that's one of the driving factors around some of the discussions at this point. And I guess we're all hopeful that things work out in a way here in the next couple of weeks that brings some certainty, obviously, for all of the companies that are doing business in the UK, Europe, and the United States.
Yes, and your remarks, your comment brings me to another issue, which is a separate track. This is not a part of those bilateral negotiations on the future partnership, which is adequacy. We're working adequacy with respect to the UK. We're working, of course, very intensively on that. But we want to make sure that when and if there will be an adequacy decision, it will be a decision that will deliver the legal certainty that stakeholders are legitimately expecting, and to ensure as much as possible continuity and stability of transfers. And that includes, and I'm sure we will come in more detail to this issue, but this includes, of course, compliance with the requirements that our Court of Justice, which is the highest court in the EU, has provided for in the so-called Schrems II judgment. So that's another aspect of our work around the UK and around Brexit.
Yeah, bottom line for today, there are a very broad set of issues that are obviously being discussed between the European Commission and the UK. I'm hoping there is a broad deal. And as part of that, because of course, UK would then no longer be part of the European Union, it sounds like ultimately, if there is an adequacy decision, the same standards that are in Schrems II with respect to assessing the intelligence and national collection practices in UK will apply between Europe and the UK for the first time. Is that ultimately where this would go, assuming there's a goal for an adequacy regime between Europe and the UK? Sure.
Schrems II is if you want to go into the Schrems saga and the Schrems story, Schrems I, the one on which both of us worked, was telling the Commission, look, your adequacy decision, in that case it was the safe harbor, is squashed because you did not include in your assessment of a third country system questions around governance and access to data for law enforcement or national security purpose. And what we learned with Schrems I is that when we find a country as providing an adequate level of protection, that doesn't mean an identical level of protection. It means a sufficiently similar level of protection, which then ensures the free flow of data between the EU and the third country. We need to follow the data. And that includes following the data and looking at the protection safeguards that apply in case of legitimate access for national security or law enforcement purpose once the data has landed in the third country. In this case, in the Schrems 1 case, the US. What now we learn with Schrems 2 is meaning what is the standard that we have to apply more specifically, and a number of issues, including around redress avenues that have to be available, and that of course is a standard that applies across the board, that applies to all our adequacy assessment and findings. So with respect to the US, if we come to a new arrangement, with respect to the UK or any other country which would be interested in entering into this type of talks with the EU. And that's precisely what we are doing right now, making sure that we can, in any assessment of the UK system, we meet those requirements that the Court of Justice has specified in the Schrems 2 judgment.
Well, look, again, that's heartening. You know, obviously, if you're in the US, it's good to hear that the same basic standard will apply around the world. But again, I'm not going to complicate it too much. It sounds like you're in the middle of a fair amount just on Brexit, Bruno. If you don't mind me picking up a similar string, just to talk about Schrems 2, but perhaps Privacy Shield. Obviously, one thing since you and I last spoke at the last conference is we now have a new president-elect. And I know there are rules of engagement that the European Commission has in place when you have an existent US, you know, obviously a sitting existing government and then a transition between administrations. And I ask about this because today, Privacy Shield is not an adequate means of transfer between Europe and the United States. And so that has a number of consequences. One, it means companies are relying largely on standard contractual clauses, which means the guidance around standard contractual clauses that have recently been issued has been very important to a large group of companies that are trying to do the right thing. Obviously, binding corporate rules, companies might be using other derogations at the moment. But there are a large group of companies, thousands of them, that were, and many of them small and medium-sized companies, Bruno, that were trying very hard to make sure they were doing the right thing by following the guidance in Privacy Shield. So for this window, you know, say between now and when there is a new administration, is there a possibility for engagement with the Commission on a new version of the Privacy Shield or whatever name? I don't know if the naming convention will stay, but is there a possibility for engagement, and where do you see that going, number one? And number two, maybe we'll come to the Schrems 2 SCC guidance in a moment, but that has been a very important thing for a lot of companies. So maybe we can tackle the SCC guidance momentarily. But anyway, do you mind if I ask, is there a possibility for engagement here with either with the government during this interim period so that we make progress on a new Privacy Shield?
Thank you. So you have asked questions around the US or around any successor to the Privacy Shield. Your question also touched about on other tools and in other tools for transfer, and also what companies should do in the meantime. Let me be very clear about the engagement with the US. There has been engagement with the US since day one. Since the day of the judgment, also before the day of the judgment, of course. So I think, and we have found very constructive interlocutors on the US side. I think that there is a willingness on both sides, and there has been willingness since the judgment to work on a new transfer mechanism. It's a bit what the same story I was telling you about the UK. We just need to make sure that the transfer mechanism is solid and can deliver that legal certainty. So there has been useful work in terms of first coming to a certain understanding of what are the requirements and then identifying what could be the solution. And that work is ongoing right now and will continue in, I can say, in the coming days. Of course, we have to respect, and we totally understand that there is a transition going on in the US right now, but that doesn't prevent us to make some progress, I would say, at a technical level, which then could be, if we would make progress or even reach at a later stage of agreement, could then be formalized once the new administration is in place. I think one doesn't exclude the other. Also, because I think that first, these are not issues that will go away will go away with the new administration, but also I would imagine that when we're talking about the interplay between privacy and national security, something which is extremely important, extremely complex, and extremely sensitive on both sides of the Atlantic, there is actually a great deal of continuity between various administrations. This is not something that falls along party lines, and we have worked, of course, with all administrations. So people who are interested in this and who are wondering what we're doing, if I can put it, be reassured, there's a lot of work which is ongoing on both sides of the Atlantic and together. And this brings me to
yeah. Just ask one quick question. So we're having in a later session today one of your counterparts, Alex Greenstein, who's just terrific and is one of the heads of the Privacy Shield program. We'll be talking from the U.S. side. But can I just ask this question and comment in any way you feel comfortable? There was a fair amount of questioning after the Schrems II decision about whether there would be the political will or the support to try again. Are you hopeful in some way that there will be a mutual desire on both sides of the Atlantic to put in place another version of the Privacy Shield, even in the face of some of the criticism that came last time?
That desire has already been expressed. There has been a joint statement in August by the two leaders on both sides, on each side, Commissioner Reinders, which is the European Commissioner for Justice, and Secretary Ross, Commerce Secretary Ross, indicating not only our willingness to find a new arrangement, developing a new arrangement, but our readiness to work. And I'm sure Alex will confirm that. Let's see how things goes. I understand that on the US side, there's now more concrete ideas about what could be the solution. As I said, there's a lot of work that can continue, that is ongoing, and that can continue in the coming days, in the coming weeks. I think one of the lessons of Schrems II is that an arrangement based on an adequacy decision is remains the most solid, or it's even more relevant after Schrems II, because it's the only instrument that avoids that you have to do a case-by-case assessment. You can rely on that finding. I can only speak for the EU, but and this will interest you, will interest the audience. It's almost live. It's coming out now. Today, the European Commission has published what we call a communication, which is paper, but an important one, which is adopted by the College of the European Commission on how we see the transatlantic relationship and our engagement with the new administration. It has been put online a few minutes or few hours ago. It's a document called the New Transatlantic Agenda for Global Changes. For global change, and it identifies a number of areas that for the EU would be important areas where we could engage or re-engage with the US. And it is interesting that a large part of the document is dedicated to digital issues, to tech issues, and amongst those issues, there is indeed as an action point almost the intensification of cooperation to facilitate free data flow with trust. So data flows that are based on common and strong safeguards. That's a further indication, I think, of our willingness and readiness. There's a lot of interesting stuff, if I may say, in that paper, including on the digital issues. And things you have already probably discussed in your event. Unfortunately, I couldn't follow it, and you will discuss today. For instance, transatlantic dialogue around issues such as responsibility of online platforms, protecting critical technologies in light of global economic and security concerns, starting by discussing on 5G. So things that are we knew are big issues that would not go away, and which are make certainly a part of our agenda. So all of this, I think, should be signs that confirm our willingness to work with our US counterparts on all these issues. And I think the work we are doing right now on a possible new transatlantic arrangement could be one of the first work stream, and we hope a successful outcome of that engagement. I don't want to be too long, but you also mentioned the alternative transfer tools. Yes, what we've discussed so far is about an arrangement that we would negotiate with the US. But there are things, of course, we can do in the meantime, and that concerns international transfer more generally speaking. You have seen probably now, I think it's 2 weeks ago, that we have published a new set of draft standard contractual clauses, which don't only try to, in a certain sense, put some more meat or flesh on the Schrems II criteria by providing, we believe, companies a very tangible, concrete checklist and toolbox of things that they have to consider to when trying to comply with Schrems II. But you've seen that this is a much broader modernization process, which has significantly changed the way we approach standard contractual clauses. We believe in a much more user-friendly way, first to have one single entry point where companies have a single set of standards, and then according to their business model, their type of transfer, where they're transferring to, can use a number of different modules. For instance, that's a big part of this modernization. In the coming weeks, we are organizing a number of, unfortunately, virtual workshop with stakeholders, both from the business community and civil society, to get feedback almost line by line on our draft SCCs. We have already based ourselves on input and feedback we have previously received, both on the SCCs and on the draft guidance by the EDPB, which now the consultation period has been extended. I wouldn't hide that this is also because this is something that the Commission very much pushed for. But I can tell you, input and feedback, if specific, on consequences, including unintended consequences of some of the ideas that we have put forward, that the EDPB has put forward, is very important. When we are talking about which safeguards to put in place, we have tried to build on certain best practices we have observed on the market. Maybe there are things we have missed, maybe there are things we have misunderstood. So really, public administration, public authorities like to consult for the sake of consulting. No, this time I can tell you we mean it, and therefore I'm sure many members of your audience will participate directly or indirectly to this consultation process. This is something we are very much looking forward, and that we want to conduct as quickly as possible. That's why we are doing this before the end of the year, so to be able to, as soon as possible in the new year, put in place these new SCCs. Well, and then you'll find, yeah?
If I may, even on that point, I will say, I do think it is very, very important that the viewers and audience know that my experience has been the same with the European Commission and with the regulators, in the sense that a specific feedback on this is something you may not realize is really important. And so I would say to everybody listening, because there's an incredible group, I can tell even from the attendees today, Bruno, of very active practitioners in our field today who are watching. By the way, if you have questions, please do post them, and Bruno and I can talk about them momentarily. But I do think it is worth everybody commenting on the drafts if you have input, because it is very likely to be processed and contemplated if it's specific. It's harder when somebody just comments, I don't like this. That's not quite as useful, but more specific, the better. I will say, from our perspective, we are and were a Privacy Shield company. We rely also on SCCs. We have done a lot. We've also had to go through in the last few months the process of trying to localize, and we have localized, in fact, in Europe. It is an incredibly painful and time-consuming, and I'm not sure overly, I mean, the number of things one has to think of to do that properly, in my view, really impedes small, medium-sized growing companies. And I think there is an impact from that, that version of it where companies are trying to localize around the world that really will not be in our interest, or at least in my view, is very likely to be in the favor of large companies as opposed to small. So let me just say on my behalf, or on behalf of other companies that are part of the Privacy Shield, it is very encouraging to hear that there is a possibility for another version of it. It is very well received that there has been so much work put into the draft SCCs, because any kind of certainty, if you are trying to do the right thing, becomes very important to companies around the world. There is ultimately some very hard questions raised in Schrems. And even with the SEC guidance, you can imagine around some of the strain, Bruno, that comes up in companies of, there is, for example, in the new SEC guidance, some focus on the likelihood of data being subject to surveillance or collection. There's also, obviously, I think, a penumbra around this on some of the OECD processes. So I don't want to go too deep into this issue, but my sense of it is the Schrems 2 issues are going to be very hard, to solve over the time period. But it is very encouraging to hear that the current administration is leaning in to try to come up, with some solutions, and that you think there's a likelihood that this will move forward in that way. I've also shared the announcement of the new transatlantic agenda with all of our viewers here. It's encouraging to see the number of things that are in there. There's a lot. I'm just looking at it now that has been announced. But on the final point,
the most important page for us, it's page 7. So if you have one page to read, go to page 7.
Okay, well, you've got my attention. I'm going to now pull up page 7. But on SCCs, do you feel like it's at a point where companies can rely on the draft in order to sort of move forward? How do companies react to that? So,
you touched on so many points. I think we could have a 5 hours discussion. But let me highlight very briefly. So first, cannot reiterate and agree more to what you said on feedback. Please, and I'm here. This is really, we don't need papers with big statements on the importance of transfer. We all agree on this. This is part of our DNA, and the COVID crisis has made even clearer the importance of transfers for any type of activity, even the interaction we have now, which ensures the continuity of government operation, of business, of human interactions, as it's the one we have having you and me, Justin, but with probably hundreds of thousands of members of the audience, relies on transfer. So we all know this. And you've mentioned localization. Our approach is not based on localization. Our approach has always, when it comes to data protection, been based on 2 elements, which I'm not saying that this is always easy, which is ensuring a high level of protection while being open to the world, while being open to transfers, which are so essential for so many activities. And that's what we want to keep. And that's why we are working with the US on a new arrangement. That's why we are working on the standard contractual clause, and that's not going to change. I think, and that also to move to another point, paradoxically or not, there is now more common grounds than there was even a few years ago to work on these issues globally. I know that a lot of our conversation now, and probably further conversations you will have with other panelists, will focus on Schrems 2, on the many complexities, anxieties, concerns, questions around Schrems 2. And that's legitimate, and I can fully understand that. But if we step back for 1 second and look at a broader picture, we see that first, there's a lot of convergence around the world right now on what are the main elements of a modern privacy legislation, from Brazil to Japan. And I don't think there's so many regulatory areas where we're seeing this. And of course, that convergence helps significantly facilitate transfers. And that concerns also the US. We have seen, of course, what has happened a few weeks ago in California. We are seeing the debate at the federal level. I always say, and always repeat the same story. When I was leading the team negotiating the GDPR and I was coming to the US 6 years ago, the question I was getting was, why on earth are you doing this thing? And it was not a very kind question. I might still hear sometimes this question, but the question moved to why, to how. I think there's a much bigger realization today that we all need, for citizens, for business, for public authorities, we all need common rules of the game in the area of privacy. And then the question I'm getting now is, what and how? Why did you do it like this? Or why did you choose that approach? But it's no longer a why on earth are you doing this? I think that will also tremendously help our dialogue with the US on this, because it's no longer such an ideological, if I may use those words, issue. It's more an issue of finding common standards, disagreeing where we need to disagree. This is, once again, this is not about identity of protection, but finding a bridge, finding sufficient safeguard. And that brings me to what you said about the OECD, which is also new, that there are a number of international fora which, because of the strategic importance of data and the increasing demand for some international rules of the games, are now looking at data protection, data flows, and trying to develop common standards. I think this is also a very promising development. It is very good that like-minded countries that basically share the same or very identical values are coming together, because we also probably prefer that we set those standards rather than other partners which may have very different ideas about privacy, about government access. The OECD now has formally launched a work stream, a track that recognizes that privacy and data flows is a multidimensional issue, that you cannot just focus on commercial data, that you need also to have common standards when it comes to government access. I think that also will help the bilateral dialogue with the US. This is not only about the US, so this is not only about the EU and the US, this is about how data moves around the globe. It is, I think, one of the most decisive debate that we can have at a global level right now.
No,
of the importance of climate change. I think there's climate change, there's data, there's not many. We are in that realm or group of things.
No, I mean, first of all, I agree with you. And you and I have talked about these issues. I couldn't agree more. GDPR, I think, and when we were first engaging years ago, Bruno, around, in 2012, 2013, there's been a huge movement around the world. And I think there are so many more actors, individuals, companies, countries around the world that are taking this issue. And there is a bit of convergence, as you would say, to a certain set of core goals. And I do think, what happened just in the last few weeks in California around CPRA, very significant. You know, CCPA originally had some pretty specific requirements that the first version of the California law that were focused really around access, you know, data subject rights. And the second version of the California law in CPRA, which was adopted, now includes all manner of requirements that I think we could fairly say are at least essentially equivalent, in my view, to GDPR, Bruno. And one could have imagined relying on the adequacy decision, for example, in Privacy Shield and some of the findings on the national security to start enabling, you know, say for example, California and other states or other countries that are adopting these kinds of very powerful laws to start getting the benefit of an adequacy finding. But a lot of that, I think, honestly, in the community that is paying attention, it really has been challenging because notwithstanding that there is a lot of lean in from the commission and others around trying to find solutions for the government access problems, there's some fundamental language in Schrems 2 that even with SECs has caused a lot of, you know, stress for companies trying to figure out what is a reliable means if we're trying to do the right things commercially. And so, you know, I don't know if you're able to comment on that, but there are some very, very difficult issues buried in that Schrems decision around redress for national government access, redress and reviewability for national government access that are simply not within the control of companies who are trying to do the right thing under, you know, international law, right? So you're stuck in this band of doing everything you can and then not knowing exactly how one can comply with something that is literally not within your control.
Indeed, but I cannot agree more. But that's also that when we designed the new SECs, we are of course perfectly aware and we recognize that companies are companies. They cannot be asked to do what legislators or executives or the executive branch in any country is responsible for. Companies are not the ones that are drafting, adopting, shaping national security laws. I think they are more and more interested in national security laws because that might have an impact on many aspects of your activities, but they are not legislators, they are not government. That's why you will have seen that in the approach that we followed on the STCs, we first took very seriously what the court said about risk assessment. We indeed believe that Schrems 2 is first of all about a risk-based approach, about carrying out a risk assessment. Nothing new, because that's a core element of our approach to data protection, of the GDPR and of many other privacy regulations around the world. And that, what it means, a risk assessment, what does this risk-based approach mean? And that goes to the question of likelihood. We believe that what the Court of Justice said in Schrems 2 is that, okay, you have a set of transfer, you need to assess all the circumstances surrounding that transfer, the nature of the data, the type of business you are in, the type of business model, of course, the country of destination, the identity of the addressee, which kind of laws apply to that addressee. And that assessment is, and that's part of the difficulty, that's why we have tried to frame that assessment through a number of factors in our draft STCs. That assessment is a case-by-case assessment that for the same country may lead to very different results, because we all know that transferring human resource data in terms of risk, in terms of likelihood that this is the object of a government access request, is very different than transferring other type of data that which may be of a larger or bigger interest for government access requests. And that's why, for instance, and that's clearly, and I can say it very frankly, this is a point of divergence between our approach in the STCs and the approach of the EDPB in their guidance. We believe that likelihood has a role to play, not as a subjective element, waking up in the morning and wondering whether I will be the subject of a government access or not, but looking at your past experience. You might have been for 5 years, 10 years, 15 years on the market in a certain business. You know whether you have been a subject, or whether the importer of the data in the US or in another country has been subject to a certain government access request. And that's, we believe, something which is an important element of that assessment. Sorry to go very much into the detail of the STCs, but this is to give an example of how we have tried to operationalize certain aspects of the STCs. And then when it comes to the question, I have identified a certain risk. Do I have to put in place a certain number of safeguards? You've seen that the safeguards we have put in place are not safeguards that are things that companies can do. Assess the legality of a access request, challenge the access request if it is under the law of the third country in question, if there are grounds, of course, for challenging that access request, or if that access request is abusive. Use the principle of data minimization to only transfer to public authorities what is required for complying with that access request. I don't think that in all of this, by the way, on many of these issues, on many of these solutions, those are solutions that were suggested by us, by companies. So those are all things companies can do to comply with privacy rules in an accountable, responsible way, and to deal with data in an accountable and responsible way. Nothing more, but nothing less than that. And that's one of the big lessons of Schrems 2, that privacy matters. You have to take it seriously.
No, so by the way, let me just say two things. I know you're on a time deadline, so if we need to wrap up, please just tell me. We'll wrap up at any moment. And again,
they haven't yet knocked on my door or yell across my door, so
quickly.
I might have another 5 minutes.
Okay, great. If you need to run, we understand. And again, we're very grateful, Bruno. You're answering very hard questions, right? We're getting to the nub of hard questions. And let me just say, I'm not going to ask you to answer all of these, because what the 3 or 4 questions that have even been posted by the community here, and I assure you we would get a lot more, these are merely representative of some of the hardest ones that I've heard. So I'll just ask 2 or 3, and perhaps you could just give a general view, because there isn't enough time, I don't think, to go into this deeply, in terms of the issue. But, the nightmare that a lot of companies probably would have, Bruno, is you don't necessarily know. You know likely or unlikely that you might be subject to a national security request. But there's ambiguity. It's not like a scientifically defined term. What is an electronic communication service provider as defined in FISA? It's just not. You can't look at it and say I'm in or out. And so the broad set of questions that probably keep a lot of the community up at night are, what do you do if you're under these regimes and then it turns out you get such a request which you can't disclose, and you're then in between 2 regimes? You can't disclose it. You have obligations around what you can do, and it becomes very, very difficult. So the 2 or 3 kinds of questions that I can imagine being very, very tough to answer are, is there some guidance around how that phrase is going to be interpreted for purposes of SEC guidance? Like, what is a covered entity, or what can people rely on in some way? I imagine the answer is no, because that would be a US interpretation of a broad term, but that's one kind of concept. Will the adequacy guidance that's coming up in the context of these SECs, is that the kind of guidance that can be used by other countries as they're going through adequacy determinations, not only the UK, but in Canada, as guidance for what will be considered in the context of reviewing their intelligence practices? But anyway, those are 2 general categories. But I'd say if you're a company right now and you're trying to do the right thing, you're probably worried that you're going to get a request that you didn't know you might be covered by, and that you still have to comply with it, and you're stuck between 2 regimes. Can you comment on that at all?
Yeah, well, I'm trying to. It's difficult to pick the one right angle to come to deal with so many questions. First, you're not supposed to know the unknown, or things that are unknown to you. That's, I think, a very simple, obvious point to start from. But what I can tell is that there is, of course, I share this not only as a representative of the Commission, but I sit with regulators. There is a profound understanding of the complexity and the uncertainty of this situation until, indeed, new tools are in place. What can companies do in the meantime? And companies think about, of course, risk, thinks about a regulator coming and knocking at their door. I think that a basic place to start from is document. Carry out your risk assessment, document your transfer, know which data you are transferring to where, under which safeguards. At least if you document that, and of course you have put in place, you have shown that you have carried out that risk assessment and tried to address certain risk, that will be a good basis to have any discussion with a regulator, which might agree, might not disagree, might require you to put additional safeguards in place, but at least it comes back to the basis: accountability and best efforts. What will not be tolerated are two things, and that, I think, applies to transfer as to any other aspects of compliance with privacy rules. Ignorance, not knowing what you're doing with data, whether it's transfer or not. I don't know whether I transfer data. I don't know under which safeguard. I don't know where. I don't even know whether I'm processing exactly which data I'm processing. So I think that's recipe for disaster, but not only in the EU, under any credible and serious privacy laws. And the other, I would say, is blatant, almost brutal violations of the law, like, for instance, relying excessively on so-called derogation on the EU law. Derogation are available for very specific transfer, not repetitive, not systemic, not structural. The idea, which I understand is sometimes aired, that, okay, forget about STCs, forget about all this mess, basically, and just rely on consent. That's a recipe for disaster if we're talking about structural transfers. And it would be very paradoxical if the outcome of all of this Schrems 1, Schrems 2 saga would be to rely for structural transfer, repetitive transfer, on the only transfer basis that doesn't provide for safeguard, but that are there for very specific situations. So I think those are, in terms of broader compliance, and in terms of also understanding, in taking into account the understanding for the current uncertainty, where those are, I think, important aspects to always keep in mind. When we have drafted and when we have prepared draft SCCs, we have, of course, preserved in our draft SCCs the elements around, in particular, that risk assessment that have allowed the court to find the SCC lawful. So although this is still a draft, I think that it is possible to draw inspiration to what we are suggesting in terms of assessment, but also in terms of safeguards. You've seen that there's a lot of discussion around encryption. We have not chosen an approach which is only a tech-based approach to safeguards. We have also mentioned a number of organizational safeguards, of legal safeguards. So I think that there you have a toolbox. Might not be a perfect one. There's no one-size-fits-all solution, but I think that they are useful mechanisms and tools to use and to draw inspiration from in what we have proposed. At least I hope it. And once again, we will carry out a consultation in the next 2 to 3 weeks, and we want to hear back, and we are very ready to consider aspects we might have simply missed.
Well, but Bruno, let me just end by thanking you again. There was a lot, as usual. I suspect you and I could have had another hour of conversation, and certainly with some of the questions that are coming up today. But just for everybody watching, you know, there's an announcement of the new U.S. transatlantic agenda for global change. I do think it's worth reading. Now, you highlighted page 7. I have to be honest, the one I keep seeing is 2 pages long. So I don't know if you were trying to test me on this, but is it?
No, that's the press release. Probably there's a link in the press release to the document.
The joint communication, is that the one?
Yeah, that's the joint communication. That's the document.
Okay, terrific. So we'll look at that. Everybody look at page 7. Bruno says that's the place to look. Number 1. Number 2, we appreciate you taking a break from very important Brexit discussions to come speak to us. We know that you're in the middle of it. Obviously, a lot going on and a deadline to work against. The conversation around that there is hope, you know, for a new privacy shield, and there are workable ways, even in the face of Schrems 2, for companies to try to do the right thing and have some certainty, is very, very helpful to our community. And you know, if you end up being able to join us, we would love it. But we certainly have appreciated your time here today, and I hope you will be back with us on the next one.
Thank you very much, and sorry for having to leave. I can tell you that if I had a choice, I would prefer to stay. But thank you again, and yes, I'm sure that we will talk again soon with you, Justin, and with I hope many of my co-panelists and members of the audience. See you soon. I hope somewhere else than in the virtual world, but
us too, Bruno. We're really hoping to get back to a normal world where we can actually share a normal conference stage together. But it was great to have you here today. Thank you.
Bye, everybody. Bye.
Bye-bye.
Great. Thank you all. That concludes this session. Thank you everyone for attending. I'd like to remind everyone that recordings of this and all other spoke sessions will be made available after the conference concludes. On your screen, you should see the agenda for the rest of the day. The next session is Privacy Tech Leaders Panel, which begins at 1 o'clock. We hope to see you there. Thanks again, and have a great day.
Thanks, everybody. See you soon.